Well, maybe the case before Judge Breyer about Trump's takeover of California, violation of states' rights and sovereignty, and commandeering of the National Guard, maybe it's not over yet. One way to read the Ninth Circuit's order in favor of Donald Trump, unfortunately 3-0, we're picking up the pieces from that now, is that the action, the case has been stayed pending the appeal on whether Donald Trump, thumbs up or thumbs down, violated the 1903 Militia Act, which we also call in the business 10 U.S.C. 12406. just to show off my powers of amazing recall. But another way to read it is that the action wasn't stayed. Only the issue that was up on appeal, which would make a lot more sense, which was whether that 1903 Militia Act was violated. But there was still one piece left out there that was still with Judge Breyer, the lower court judge in federal court, about whether Donald Trump violated the Posse Comitatus Act. The Posse Comitatus Act is a fancy way of saying that a president can't turn the awesome power of the U.S. military towards Americans and use them for law enforcement purposes or other purposes like that on domestic soil. And there's enough evidence that had been developed and that Judge Breyer was getting to the bottom of about whether Donald Trump had violated it, especially using the Marines to detain and arrest people. And the judge even, by the way, Judge Breyer had delayed or had denied an attempt by Trump to delay last week having this Friday hearing, which didn't happen because of the appeal, because he argued, well, we're up on appeal. We're waiting for the Ninth Circuit. But the judge says, yes, but I still have the Posse Comitatus Act piece that hasn't been decided. So my thought, the better, more prudent approach by the Ninth Circuit would have been to allow Breyer, with proper instruction, to continue to develop the record of the Posse Comitatus Act and or to develop a more fulsome record on whether Donald Trump violated 10 U.S.C. 12406, the Militia Act of 1903, and kind of give it to him with instructions, knowing the hearing was on Friday. They said they knew the hearing was on Friday. That's not what they did. And I'm going to tell you what they did and what Breyer has done in court today to set up a new briefing schedule about the Posse Comitatus Act starting on Monday. Isn't that why you come here to Legal AF? To get this kind of inside baseball, TED Talk meets a law school class, but presented in an entertaining way? I hope so, because that's what we're doing. And while we're here, hit the free subscribe button as we continue to grow this pro-democracy channel as well. The better procedural and substantive argument is that Judge Breyer retains jurisdiction over the Posse Comitatus Act because he's not done with it. It wasn't ripe for appeal. It wasn't up on appeal. Therefore, they didn't stay the action. They only stayed the portion of the case that was in front of them. I mean, when you read their order, it was a little bit muddy. It just said that the motion for stay was granted. That's it. And Donald Trump asked for a motion to stay, like on the case, but he also asked for a motion to stay about the temporary restraining order. They could have done some clarification there, but they didn't. And so Judge Breyer, on his own, pulled the parties together, made a joke about everybody up late last night because the order came out kind of late last night, and said, I still think there's things procedurally we need to discuss. He said, particularly the Posse Comitatus Act. Now the judge has seen the renewed evidence that indicates that Trump violated it. And I think he's feeling his oats. Like the judge is like, look, that portion of the case about 10 United States Code 12406, the Militia Act of 1903, I get that. That is stayed pending the appeal. In other words, the court has said, we want to get to the bottom of the appeal. It's going to take us 6 months to a year. And in the meantime, what Trump did was okay. I did a separate hot take about whether Gavin Newsom, I don't think he has a choice, goes for an en banc appeal before the 29 judges of the Ninth Circuit. It'll end up being an 11-judge panel, but you know what I mean. Or takes it to the United States Supreme Court. But this open issue, this tail wagging the dog of the Comitatus Act, is important. So look, he's setting briefing. He wants the parties to brief him by Monday about whether he retains jurisdiction, despite the Ninth Circuit decision appeal against him, on the Posse Comitatus Act only. Gavin Newsom is going to argue that he does. Trump's going to argue that he doesn't. The Ninth Circuit may get asked to weigh in again, but we'll keep you posted the only way we know how, without blowing smoke or sunshine. You're here on the Midas Touch Network. You're here on Legal AF. We're trying to build this channel up to kind of come close to the channel, of my big brothers, so to speak, and their 5 million. So procedurally, and I've said this before, I think the Ninth Circuit was wrong. I think what they should have done is send it back to Judge Breyer for his further trial court work and stay in their seat and in their role as an appellate court. But once they found that a 1827 Supreme Court case involving James Madison and the federalization of the New York militia was the prevailing law, and we could certainly quibble about whether that's right or wrong. And that had to do with the War of 1812. Once they found that and they went to the next step, which is to find, yes, we're allowed to review what the president does in this arena, but we have to be highly deferential. As soon as they said highly deferential, I was like, all right, this is not good. This is not a good sign. This is not a good sign. But Posse Comitatus Act, they're going to have to assess that all over again. It has to be briefed and litigated somewhere. It's not supposed to be litigated in appellate courts. They're only for reviewing of what's developed below on the record below. So the more I talk through it here out loud, the more I'm reasonably convinced that Breyer is going to try to go forward with the Posse Comitatus Act with his jurisdiction, unless and until he's stopped by the Ninth Circuit. So we'll follow it. We'll know on Monday. He'll probably rule Tuesday, Wednesday. Could the Ninth Circuit clarify their order? In the meantime, they could. They know what's happening below. So if they stay silent, I think that reinforces for me that they think that the question of jurisdiction still needs to be addressed and briefed by the trial court. In other words, stay in your lane. If you're an appellate court, I don't even think they should have asserted jurisdiction. I've said this before. Temporary restraining orders are not the place for appellate courts to assert their jurisdiction. They're limited appellate jurisdiction. After a preliminary injunction, and there's a full record, sure. But they did it anyway. They stepped in when I don't think they should have. I think that's part of reversible error to be considered by the full panel or 11 judges of the en banc. And then we'll have to see what happens to the United States Supreme Court. But we'll continue to follow it. You're on Legal AF. Take a moment, hit the free subscribe button. Come over to Legal AF, the Substack, where we post, where right up right now are these filings and these orders, so you can take a look. And the rest, along with commentary, you can only find one place, Legal AF. So until my next report, this is Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.